Did you go to the hospital?
Yes.
Tell us about what happened at the hospital.
When we got to the hospital, they put me and my sister in a room, and they had came to talk to us and said, well, the lining of his stomach is gone. We have to do emergency surgery, but we are prepping him to go to children. They went back.
Did you say children's hospital?
Yes.
Okay. Continue.
They was prepping him to go to children. His heart stopped. They got his heart back. They came back and said, well, we got to do the surgery here.
To hearsay, and then we approach.
Your Honor, we can approach. Should I respond to the...
Yes. Address the objection first.
Your Honor, statements for the purpose of medical treatment, that's what they're saying, and so I think it doesn't go to the truth of the matter asserted here. It's not hearsay, but even if Your Honor did find, I think it's part of the medical treatment.
Okay. You wanted to say to that?
No, I want to approach sidebar.
Okay, so your sidebar is in regard to this?
Yes. Ma'am.
Yes, sir, please. All right, back on the record with People versus Geneke Lyons, case 1506237. We had an objection on the record by defense counsel. The prosecution had an opportunity to address some of that, but I think before we continue with this, I want to ask the witness to be put back in the witness booth momentarily. And the objection has been made. You want to restate it?
I can if the court wants me to.
Why don't you,
Yeah.
just in case?
Your Honor, just to put it into context, the witness was being asked to describe some very graphic events that at this stage we're not real clear as to whether she was personally in the room witnessing these events or not. But the objection was that twofold. One is that that information regarding the medical treatment, regarding ultimately the result, the very regretful and sad result of this young child has already been admitted into evidence by stipulation, by agreement, Judge, between the defense and the prosecution by way of, I believe it was actually the first exhibit, if my memory serves me.
It is.
That would have been the medical examiner's report. Not only that, Judge, but that medical examiner's report has been published in the sense that you've had an opportunity. You as a jurist who has to be satisfied that the people have established their threshold at this stage, you've reviewed that medical examiner's report, the narrative, the graphs that were attached to it, photographs, etc. And all of those things have now been established in terms of what happened to this young child, regrettably what happened to this young child, described aptly by the medical people, by the statutorily authorized and duty-bound medical examiner. So I think that what the prosecution at this stage is purporting to add on the record, and I think I told you in chambers that this isn't about the prosecution or I. It's about fairness and due process and making sure that we do this in a fair way for both sides. And if I didn't say it, I'll say it now, that it's about fairness and due process for both sides. But to amplify some graphic information regarding this poor young child and what the medical people may have done is cumulative. It is highly prejudicial. It is nothing more than to add what I said in chambers, lemon to the wound that we don't need. So since that's been established, I think it's highly prejudicial, and I think it's cumulative, and I don't think it's proper that it be permitted at this stage.
Thank you, sir. You want to say, ma'am?
Yes, Your Honor. The people would submit that while there may be some prejudice, we don't think that it is so unduly prejudicial that the probative value is outweighed, which is what the rule of evidence indicates for prejudicial evidence. We believe that the medical examiner's report does indicate some of this information. However, in proving several elements on several counts, it's necessary to establish the facts underlying. The dangerousness of these dogs, part of that goes to the viciousness of this attack, to the totality of the circumstances of this attack, Your Honor. We're not just doing it for the sake of getting it out, but we believe that it goes to the heart of the elements and it has probative value. And we are not asking the court for, detailed descriptions of what was going on. We're just asking for generalized descriptions of what happened. And we would argue that the condition of the child, of Xavier, and his nature of treatment, immediately responding, and then immediately to the scene, after the scene, and immediately prior to his death, and what ultimately his death. This is all within a matter of a couple hours, and we're just asking that the evidence comes in because it goes towards the totality of the circumstances and to several elements when we have to make the argument. So we're looking to establish a record that we can then go back and make these arguments when it's time to address the bind over, Your Honor. And as I indicated, it's the people's position, and we don't have medical records at this time. I did receive some. I don't know if they're complete. I told defense I copied him the ones I have, but we don't have medical records. We have a medical examiner's report, but that does not indicate what happened at the hospital with this child. And it's our position that in a case like this, with the charges we have, that it is probative, and that while there is some prejudice, perhaps, that the probative value does outweigh the prejudice. And so we would be asking to continue this line of questioning, and it's not going to be a very long line of questioning. I can tell the court that.
All right, very well. Is there anything else you want to say, sir?
Well, Judge, she said a lot, but I don't see really what should be glaring to us, and that is, what is the probative value of this? Clearly, it is prejudicial. Clearly, it's cumulative, and what was done to the child in the hospital is not an issue. It's not an element of the offense. What the medical people did in their good efforts to treat this child as they should and as they were duty-bound to do. It's got nothing to do with any of the elements of the offense. The court has viewed not only the medical examiner report with its extensive findings, but also the video of the events. That's the totality of the circumstances, Judge, the video of what happened to this young child. So when she talks about we want to be able to show, even though it's prejudicial that she's not acknowledged, she wants to say, I want to show the condition of the child. It's not relevant. It's not relevant to the charge. Secondly, she talks about, well, we want to be able to show the dangerousness and viciousness of the attack. Well, that's a fact question that you will have to determine based on what you saw in this video. The mere fact that the medical people, in their good efforts, attempted to render the best aid possible has nothing to do with any of the elements of the offense, and they certainly have no competence whatsoever to talk about the dangerousness of an animal. And finally, Judge, I think it's inappropriate to highlight this type of information in light of this case and the nature of it.
All right, thank you very much. Both of you. Let me say both. Let me say, first of all, both of you are doing a stand-up job in this matter. We're here to see if the prosecutor can establish probable cause of each element of each charge to the city of Detroit, and that this defendant, we can find probable cause that he is the defendant, that he committed it. All right? So what the prosecutor is trying to do, and I understand you're trying to prove your case, but we're here for probable cause for each element of the charge here. So as far as the probative value, the court feels that the medical examiner's report is thorough. It even includes some information, as I glance over it now, regarding the surgical incision, the defibrillator used, that sort of thing. We have that. The court is aware, and the report is 5 pages long with 3 diagrams. So the court is going to rule on behalf of defense counsel at this time, or I'm going to sustain your objection at this time. We have what we need. It is cumulative at this point. So let's move on. We can call the witness back if there are any other questions. If we were in cross.
No, I think she's still direct.
We're on direct.
Okay. We're on direct?
Yes.
Not redirect, but direct.
Direct.
All right, then. Thank you.
I'm just wondering whether it'd be a benefit that the prosecution have a word with the witness so that we don't go there.
Pardon me?
That the prosecution may have a word with the witness so we don't go there to describe any of these things.
If that's what she wants to do. Is that what you want to speak with her beforehand? Or?
I mean, I can make sure that I don't ask questions, but if it'll make defense counsel, I can let her know before I come back out that we're not going to get into those details.
And then when you're ready, have her come out.
Yeah. It'll just be not even a minute or so.
Mrs. Strickland. Please make yourself comfortable again in the chair. Put the microphone against your mouth. We'll continue with the examination by the prosecution.
Yes.
Okay. Ms. Strickland.
Yes.
Let me ask you this: did Xavier? Did you ever get to see Xavier at Henry Ford Hospital?
Yes.
Okay. And did you get to take Xavier home from Henry Ford Hospital?
No.
And did he go to any other hospitals?
No.
After Henry Ford Hospital, did you see Xavier again?
Yes.
And where was that?
Your Honor, I'll stipulate that this young child was identified.
Oh, okay. And that's where I was going. Thank you. So I think the stipulation on the record is that Ms. Strickland did identify Xavier Strickland at the Wayne County Medical Examiner's office.
So stipulated.
And Ms. Strickland, you testified. You testified that when you would try to walk by the house, the dogs would growl.
Yes.
And you testified that sometimes you would walk in the street.
Yes.
And why would you walk in the street?
That's been asked and answered at least twice, Judge. I think we should move on.
Okay.
Do you want to address the objection?
You know, if I may have asked,
Yes, you have.
yeah, then that's fine. Are you scared of dogs?
How's that relevant, Judge?
You know, when there's an objection, you have to
Yes.
address the objection.
Right, no,
So it surprises me when you
No,
look
no,
at me like...
no. I was just,
Okay.
yeah. I didn't know if I should respond yet or not, but okay.
Sure, yeah.
I think it's relevant because she's describing these dogs in a certain way, and there have been other witnesses that have described dogs in a certain way, and whether or not she's scared of dogs go to her impression of whether or not dogs are scary and vicious. So if she is not scared of dogs and she finds these dogs to be vicious, then I think that goes to the nature of these dogs from her opinion. It's just her opinion of it. So I think it's highly relevant.
Anyone to say
Your Honor,
something?
with all due respect, I don't know of anybody in this courtroom that's an expert on dogs and whether they're vicious or not vicious. Certainly, with all due respect to this lady, she can't claim to have that expertise either. And whether she's afraid of dogs or not afraid of dogs is not relevant to what happened at this time. In the line of question that I hear.
So you're seeking to find out her perspective
I'm not,
as to how she feels about dogs.
and I'm not asking her expert opinion. And the defense counsel was questioning another witness about their fear of dogs. So I don't understand why it's now irrelevant.
Judge,
I mean, if she's afraid of dogs, she is. If she's not, she's not. I'm not asking to belabor the point. I'm just asking, her experience with dogs?
All right.
And I'm not asking it as an expert in any way, shape, or form, but the rules of evidence allow opinion testimony by lay witnesses, and the court can give it the weight it wants to give.
All right, the court will allow it.
Are you experienced with dogs?
That's a different question.
Well, I'm sorry. What was the question that I asked?
Are you afraid of dogs?
Are you afraid of dogs?
Now I am.
Before this incident, were you afraid of dogs?
No.
Have you ever had dogs?
Yes.
Did you... What kinds of dogs did you have?
And how is that relevant, Judge?
Yes, ma'am. Do you want to address that objection? How is that relevant?
Again, I think it's relevant to show, because I think it's relevant to show that she's afraid of dogs now. What kind of her experiences she had with dogs before?
I don't think so. Stay.
Are you afraid of pit bulls now?
Yes.
Were you afraid of pit bulls before this incident?
No.
Did you ever own any pit bulls?
No.
Did you have interactions with pit bulls before this incident?
No.
And you previously testified that your daughter had an incident with the dogs one time?
Yes.
Did you have do you have any personal knowledge of any other incidents with the dogs, either for yourself or for anyone else?
No.
Thank you.
Your witness, sir, cross-exam.
May I proceed, Your Honor?
Please.
Good afternoon, Ms. Strickland.
Good afternoon.
Ms. Strickland, let me first indicate to you my deep condolence for the loss of your child.
Yes.
And I mean that sincerely. Although I'm the lawyer for the defendant, I mean that sincerely.
Yes.
And I'm going to ask you just some very basic questions about a couple things.
Okay.
Can you tell me how long you lived in this area?
It will be 2 years.
Okay. You told us that there was an occasion where one of the puppies or one of the dogs, was it the dog or was it the puppy that grabbed your daughter's book bag?
The dog.
Okay. Did you ever report that to the police department?
No.
Did you ever report that to animal control?
No.
Did you ever go and leave a note for the homeowner about the dog being out and having had contact with your daughter's school bag?
No, because you cannot walk up there.
Okay. So you never have been to the house on Bayless and knocked on the door?
No. Because you cannot walk to the step to get to the porch.
Okay. And on the many times that you walked through there, have you seen the mailbox along the side of the fence that runs on the service drive area?
I did not pay attention to that.
Okay. Thank you very much, Mr. Strickland.
You're welcome.
Thank you. Any redirect?
No, Your Honor.
Thank you very much, ma'am, for your testimony today. You may step down.
Thank you.
Your Honor, we have no other witnesses that were available for today. I know that yesterday we had discussed potential child witnesses. Defense had some trouble viewing the DVDs. I did speak with someone in his office, and after playing around with it, she was able to get them to work. I don't know where defense stands in terms of that right now, but I know that was an issue, and that might be an issue before we set a new date.
Court is looking at the week of the 4th, of course, and we're looking at later in the week.
I'm not available on January 8th. However, I should be available later in the week, the 7th.
Later in the week.
The 7th is open.
7th work for you, sir?
I'm prepared to go on the 5th, Judge. The sooner the better.
We can't go on the 5th. We're swamped. So it needs to be, I do believe 6 or 7.
But I'm available on the 6th as well, Your Honor.
And I think the 6th is swamped. If the Madam Clerk is not here, yeah, it is, because we tried to do it earlier with the 6th, so I think it needs to be the 7th. You said the 8th won't work for you, the 7th doesn't work for you, sir, or?
The 8th would work if ordered to be here.
Does the 7th work?
The 8th would work if ordered to be here.
Now, if the prosecution can't be here, I'm just trying to, right now, get a mutually convenient time.
I have a matter in Rochester on the 7th. I would not be available to be here till probably closer to 11 o'clock.
What about, well, we'll probably do that then anyway, I'm thinking, because...
Can we make it a firm 1 o'clock?
No.
You know, we little Mexicans still like to eat rice and beans, so I gotta have lunch somewhere.
I tell you what.
11:30?
What about that Monday?
11:30?
What about the Monday?
I have a federal trial on the date.
Which Monday are we talking
The
about?
next Monday after.
I'm starting a trial on Monday, Your Honor.
All right, well, it needs to be the 7th then. It needs to be the 7th. It's going to be
11:30?
It's going to be scheduled at 11:30.
That's fine for
It's
the people.
according to how the docket runs. I can do you today. I mean, I can do you on that day like we worked it today. That's what we have to do when our, matters are adjourned. It's just the nature of Wayne County Court right now. We have to, schedule accordingly as best we can because we have a full docket every day. So that's what we'll do. And unfortunately, judges don't do the scheduling. let that be known. When we do things here, we're so used to doing things as attorneys, prosecutors, defense counsel, we forget that the general public doesn't know. Judge doesn't make her own schedule, except for when I ask if we're going to adjourn. But I was thinking that I would give you a whole day, and if we put on there, that there's potential 14 witnesses, and there wouldn't be any cases put on my docket, and I was laughed out. So that doesn't happen. Okay, that doesn't happen at all. So we just have to work with what we have. So the 7th it is, let's say 11 o'clock. We understand the nature of everybody being busy having other cases, especially in the beginning of the year. We'll just do what we can. That's all we can do. That being said, thank you very much.
Your Honor, before we conclude, I'd like to address the issue of bond.
Okay. The bond currently, I think, was $1 million.
Yeah, it's still $1 million, Judge.
Okay.
It's $1 million bond with tether, house arrest, and a number of other conditions. And I'm not going to re-argue all of the factors on the bond issue that are noted both in the court rule as well as the case law that I cited in my motion. In fact, you should probably have in the court file a transcript of that bond hearing at that time. Shortly after that bond hearing, I did in fact request, and the court granted, a referral of Mr. Lyons' bond request modification to the pretrial services office. I have obtained, through the assistance of your efficient staff, a copy of that pretrial services report that had been prepared by what is known as Senior Pretrial Services Officer, a gentleman that is listed on the report. And that report, in essence, reiterates a lot of the fact information that I provided the court back then, and that is that Mr. Lyons has no issue or history of failing to appear. So they claim in the report, and they corroborate that there's no evidence that he's ever failed to appear. There's no history of him failing to appear for any court appearance ever. They confirmed that he's a United States citizen. They confirmed that he's a Michigan resident, that he's a lifelong resident of the city of Detroit. And they confirmed his residence at the address that's noted for the past 6 years. They've also confirmed where he would be released in the event that the court was to modify the bond that we're requesting to a reasonable bond. And they noted the location of where he would be with a number of conditions that would include, in essence, the tether that the court had ordered before. They confirm his employment. They confirm a history of education. They confirmed that he has a medical issue that I believe is nonetheless being taken care of while in custody. And they confirmed that the history that's noted, and I don't think we need to note it for the record because part of that stuff is confidential and because it's matters that were, for as I saw that in the big red stamp FBI use only, that dealt with his prior contacts, because you may recall that I argued that he had no prior criminal record, and I stand by that in light of what happened, in light of the records that we have. So in light of all of that, Judge, now we have a neutral entity that is attached to the court whose responsibility is to verify the information that is furnished to the court by not only the defendant, but what's offered by his counsel in suggesting that the court modify the bond to a reasonable bond. And that's what we're asking you to do. The recommendation that they make, Judge, as I reviewed it, is that even though, and here's what they say, that even though they took all the risk factors, and this is the important thing, even though they took all the risk factors that talk about the purpose of bond, which is ensuring that he's going to appear and danger to the community, they took all those risk factors and they analyzed it and they compared it with everybody, not just picking on Mr. Lyons, but on everybody that has to go before that department that is neutral and an arm of the court. And they categorize him after evaluating it at being at level 1. So they indicate very affirmatively that he has no negative risk factors, none whatsoever. They confirm that he has strong family ties. They confirm everything that has been suggested to the court by way of the record that I made before, and they're recommending that even though the risk factor will recommend a high personal bond, I have never asked for a personal bond just based on the seriousness of the offense, because I know that's one of the factors that are noted in the court rules. But they say that because of the nature of the offense, they're going to deviate from what would normally be required, and that is that a high bond. I'm asking this court to consider adopting their recommendation of the $75,000 cash, surety, or 10% bond. It's a huge bond. The $1 million bond, with all due respect, and I've practiced before you, with all due respect, is a remand. This is not a remand case. And even though we bite the bullet and we take what judges say as officers of the court, we believe that that bond you said previously was excessive, and we believe that now the recommended bond, in light of all the things that they've reviewed, is an appropriate bond. More importantly, Judge, you've heard the testimony, and we're not going to hide behind anything that is on this record. So we know that this is a very, very, very sad type of case for both sides. For both sides. And we'll make the argument on the bind over at the appropriate time. But I say that only because you are the examining magistrate that not only is at this stage duty-bound to make a ruling on the bond, but also can assess what you've heard so far as you determine whether a reduction or a modification of bond is appropriate. We believe it is, and we ask you to respectfully consider that.
Thank you, sir. Anything you wanted to say, ma'am?
I haven't even had an opportunity to view that DSU report or this pretrial service report. I was not told it was ready. I would like to view it before I even respond, if that's okay, Your Honor. Unless Your Honor is inclined not to change the bond, but I believe
you need to look at it anyway.
Yeah. May I approach?
Yes, please do.
May I, Your Honor?
Yes.
The people would object to any decision before the close of the proofs and the bind over or whatever happens at the close of the proofs. We believe that the court should hear all of the evidence. The defendant is facing homicide, murder, 2 charges, which carries prison time, lengthy prison time. While the defendant has a criminal history that has been expunged, he does have a criminal history. He also, while he's a lifelong resident of Michigan, he also has contacts, ties to Texas and Arizona. Those are other states, Your Honor. It's listed in that pre-sentence report that have been confirmed contacts of things that were happening both in Texas and Arizona with respect to this defendant. He also has used an alias, which they indicate on there, and in my law enforcement, in his lien, it indicates an alias with the last name Watson, Your Honor. These are all reasons that are factors that actually make him not a low risk. These are all factors that make him a high risk, Your Honor. We don't think that a reduction in bond is appropriate. We think that it's not appropriate to address bond at this time. And we would ask that you keep the bond as it is until we conclude the preliminary exam. And then, if it becomes necessary to address bond, then we address the bond. But we have very high concerns for both, and at this time, primarily, his ties to other states over many different years, his criminal history, his use of an alias. These are all concerns of the people, as well as these charges that he's facing and the dangerousness of the situation that was created by him. So we would object to any change in the bond, and we don't think, even if your Honor is inclined to consider a bond, we don't think it's appropriate to do that until the closing of the proofs of the preliminary examination.
Well, the court will entertain any motion. This court entertains motions that are brought before her at any time. You wanted to say something else, sir?
I'm just surprised, Judge. I expected more factual, verifiable information from the prosecution. She alleges in her response to the bond that he has ties to Arizona. What you have there, Judge, is an entry that he had a contact on in 2007 in Arizona. That's all it was. It's a contact in Arizona. There's absolutely no evidence whatsoever that he has any residence, that he has any friends, that he stayed there. There's nothing there. There's also a noted entry, Judge, of the same case, and I tell you, as an officer of the court with a P34147, that the same entry regarding Wheeler, Texas, is a case that I represented him on. I flew to Texas on many occasions with him to litigate that case. And what do they tell you? And what do I tell you? That case was dismissed. It was dismissed. It was dismissed, Judge. Insufficient evidence. It was dismissed after reviewed by 2 different prosecutors in that county. We lost the question of the money because there's some other issues regarding that, but it has nothing to do with contacts with Texas. Yeah, we got to go to Texas because he was duty-bound to go to Texas and appear in court. And I went with him. So to him, to hear that he has all these contacts in these other states is disingenuous. Look at the report, Judge, and they say he has other aliases. What do they say? They say Geneke Lyons. Geneke Antonio Lyons. That's his name. Sometimes when I go and I request even a flight a confirmation, because my name happens to be long, they don't put the last 2 or 3 words in there. That creates an alias. Sometimes with Hispanic clients, they have the mother and a father, but when they book them, they forget about the mother and they only use 1 last name. We have 2 last names. No, he's got an alias. So this thing about aliases has nothing to do with Mr. Lyons. Judge, I think that we can raise the question of bond anytime. We're entitled to a review of the bond at any time, and I think that you have enough here to make a determination on that bond.
Your Honor, may I briefly respond, only because I didn't want to put some of those specifics on, but I'm going to now. His ties to Arizona and Texas are criminal charges. Now, they may have been dismissed, but this defendant has criminal activity in states Texas, in Arizona. Talk about a flight risk and a danger to the community, potentially. Also, the money that was lost, that's over $100,000 cash that was in the defendant's possession that was lost, Your Honor, that was tied to these charges. And I can't speak for why they were dismissed, and I have to defer. I was not there. But the point is, he was charged in different states, Your Honor, whether or not there was an outcome. This is not just some guy that happened to be traveling to other states. He has a criminal history in Michigan. While it's been expunged, he does. And I have, and if Your Honor wants to approach, I have the law enforcement identification network, whatever it is, the form that the police pull for criminal history, and it specifically says the last name associated, the offender names, type alias, Geneke Watson. There's no Lyons, Watson. W-A-T-S-O-N. That's a completely different name, Your Honor. That's not a mistake of a middle name or a middle initial as defense counsel saying Watson. W-A-T-S-O-N. That is known as an associated name with this offender.
Thank you.
So, well, I was just going to indicate, so what we have is we have the defendant all over the country. We have him involved in multiple potential criminal activities. We have him with large amounts of money that don't seem to be accounted for in what his documented and known and verifiable lifestyle is.
Thank you. Thank you very much. I've heard the argument. I had an opportunity to look at the pretrial investigation summary as submitted by, let me make sure I get the name right, Lee Brown, Senior Pretrial Services Specialist. This is a recommendation that service that's offered to defendants. Both of you all have had a chance to review this as well, maybe the prosecution not as long. These are what are considered recommendations, and they give risk factors. And I will say that the recommended bond of Mr. Brown is $75,000 cash assured 10%. Defense counsel has indicated to the court that in his opinion, he believes it's excessive. The court doesn't believe so, and the court will continue the bond as it is now. So that being said, is there anything else at this time? Have a great day.
One other matter.
One other matter? Okay.
Unrelated to what you just did, but I do want the prosecution to be at sidebar so I can show you something.
And
well,
and I don't know that this needs to be on the record or not, but you did give us the exhibits back that had been omitted, and I was going to ask the court if you wanted us to give them back to you now, the people's in defense
until we can finish the exam up. But I guess what I was saying, well, we're doing some sidebar now, so we're not at recess yet.
It won't take a minute.
It's okay, however long it takes, that's fine. That's the issue.
Gene was not admitted?
No. But she can hardly get it.
back on the record. I have the exhibits as admitted. I do believe we're in recess now. Thank you very much, everyone. Everyone have a good holiday.
Thank you.
So is it limited to those two?